James Phelan, a defense attorney, provided the most recent information regarding the ongoing case between the SEC and Ripple on Thursday, April 20th. He stated that Magistrate Judge Netburn has entered a scheduling order regarding Ripple's motion to strike new expert materials the SEC finally submitted in support of its motion for remedies and entry of final judgment. Judge Sarah Netburn granted the Securities and Exchange Commission SEC until April 29 to submit a response to the Ripple motion to strike as stated in the accompanying scheduling order. Ripple was given permission by Judge Netburn to submit a reply brief 3 business days after the court received the opposition brief. When the Securities and Exchange Commission C will respond to the opposition brief filed by Ripple is not related to the court briefing timetable, the Ripple motion to strike is closely related to the briefing schedule that has been created. The motion to strike was submitted by Ripple on April 22. The motion asked the court to strike fresh expert papers that were supporting the opening brief submitted by the SEC. During the discovery process, Ripple alleged that the Securities and Exchange Commission SEC included testimony from Andre Fox without disclosing her identifier, her testimony. When it comes to the enforcement section of the SEC, Andrea Fox is an accountant. In order to provide evidence in support of the SC's request for a $2 billion fine, Fox investigated Ripple's financial statements as well as other data. Importantly, the Securities and Exchange Commission C also made an effort to identify Andre Fox as a summary witness to Ripple. Summary witnesses are not permitted to provide any new information and are only permitted to summarize the material that has already been discovered. In accordance with the agreement reached between Ripple and the SEC, the C would have 5 business days to submit a brief in opposition to the motion to strike. In light of the fact that the filings are so close to the deadline of May 6 for the SEC to submit its reply brief, as investors process Ripple's announcement of its stablecoin and the company's answer to the Securities and Exchange Commission's request for $2 billion, the price of XRP erased the gains that were made on Monday. In an interview with the Digital Frontier, the senior vice president of Ripple indicated that the company intends to launch its stablecoin on the XRP ledger, which will ultimately be beneficial for the ecosystem. Miltenberg provides evidence in favor of his claim by referring to Polygon's example of how the release of stablecoins led to an increase in the total value locked TVL on the chain as well as an improvement in confidence. Santosomo Saba, a crypto expert based in Tokyo, posed a question to David Schwartz, the chief technology officer of Ripple, inquiring about the possibility that part of the cash equivalents that are going to underpin the USD peg stable will be the digital currency XRP. That, guys, you have to see this. SEC given 3 days to counter Ripple's motion to strike. Ripple possesses. Schwartz is questioned by the expert regarding the comparison between the growing use of stablecoins and the utilization of TVL on the blockchain. Representative Bill Morgan brought to the attention of XRP holders the possibility that a decision on Ripple's on-demand liquidity corridor could have an effect on the asset. The open decentralized ledger is Ripple's approach for managing liquidity, which enables immediate transfer of funds and transactions across international borders. It is the native token of XRP ledger, XRP, that acts as the bridge currency for the liquidity management solution that Ripple provides. Morgan contends that if the court decides to issue a permanent injunction, which is just another way of saying an order to stop a particular conduct regarding Ripple's utilization of XRP in the ODL, it may have a detrimental effect on the asset's usage as well as its price. XRP holders are understandably concerned by this development. Ripple's launch of its stablecoin and the recent response filed against the Securities and Exchange Commission's request for $2 billion in penalties are the primary market movers that have the potential to influence the price of the asset being held by XRP holders. A scheduling order has been issued by Magistrate Sarah Netburn in response to Ripple's move to reject one of the SEC expert documents that was submitted in support of its remedies application. In the ongoing legal battle between the Securities and Exchange Commission, SEC, and Ripple, fresh developments have continued to emerge, which may have an effect on the result of the case. In the most recent turn of events, United States District Judge Sarah Netburn issued a new scheduling order that was centered on Ripple's move to exclude fresh expert materials that the Securities and Exchange Commission provided in support of its remedies-related brief. Ripple also submitted a request to strike expert materials, which the commission provided in order to further support its entry for final judgment and motion for remedies. This was in addition to the opposing brief that Ripple had prepared. Ripple asserted in this motion that the Securities and Exchange Commission did not share the expert documents that Andre Fox, one of the commission's top accountants, had prepared during the discovery phase of the remedies case. At the same time that it filed its opening remedies brief, the Securities and Exchange Commission instead provided the expert documents. As a consequence of this, Ripple said that the action taken by the SEC limited its ability to adequately address the specifics of the expert assessment. As was to be expected, the Securities and Exchange Commission did not agree with Ripple's move to strike the expert papers. In order to settle the matter, the parties proposed a new scheduling order has been entered by Judge Netburn. Magistrate Netburn has entered a scheduling order in relation to Ripple's move to strike, as stated in the most recent update. James K. Filan has released an order that states the Securities and Exchange Commission has until April 29 to provide a response to Ripple's request. After that, Ripple would submit its response 3 business days after that, which would result in the date of May 2, 2020. It is important to note that Ripple anticipates submitting its response 4 days prior to the Securities and Exchange Commission filing its response to the company's opposition brief concerning remedies. It is possible that the judgment made by the court about whether or not to strike Fox's declaration will have a significant amount of weight in determining the ultimate outcome of the remedy stage. The audited accounting of Ripple and the penalties for XRP's institutional sales are the primary topics of discussion in the expert report. Excluding it could have a detrimental influence on the possibilities of the Securities and Exchange Commission successful in obtaining a court to impose a fine of roughly $2 billion. In the meantime, the cryptocurrency community was informed of some intriguing information earlier this week concerning the nomination of Netburn to the position of federal judge in the United States District Court for the Southern District of New York. The Supreme Court of New York is the same court that Netburn has appointed as a magistrate in a number of instances, including the Ripple petition. It is interesting to note that President Joe Biden put forward her nomination along with 6 other individuals for judicial posts in federal district courts. Cryptocurrency aficionados respond to Netburn's nomination in a variety of ways, with Paul Grewal, the chief legal officer of Coinbase, applauding her for putting on a masterclass for the sector. It is impossible to overstate the significance of Netburn's role in the SEC versus Ripple dispute. It is because of her criticism of the SEC's lack of loyal commitment to the law that members of the XRP community are familiar with her. Additionally, she issued an order to the Regulatory Commission requesting that they hand over to Ripple the drafts of William Heinemann's infamous crypto speech from 2018. Netburn has the potential to oversee notable cases, particularly those that are associated with the cryptocurrency industry, if she is nominated.